I'm Catherine Meredith, a barrister at Doughty Street Chambers. I'm giving an update today on recent developments on the protection of victims of trafficking. The political will to put in place law and policy on the protection of victims of trafficking needs to be matched urgently by the implementation of commitments in practice in order to really make a difference to protect victims. That was the message of a special event held in Chambers with the EU Anti-Trafficking Coordinator, Mireia Vassiliadou, and it's of real significance today as the Modern Slavery Bill reaches the report stage in the Lords. It's also what I'm going to briefly speak about today. So turning to the written commitments to protect victims of trafficking. The Council of Europe Convention on Action Against Trafficking in Human Beings was ratified in 2008 by the UK and entered into force on the 1st of April 2009. The same day, the National Referral Mechanism for the Identification of Victims of Trafficking, the NRM, began its operation. I should point out that now all Council of Europe member states are bound by the convention except Turkey. And just a couple of weeks ago, Estonia ratified the convention on the 5th of February 2015. As an aside, that's important for the UK when it comes to cross-border cooperation, especially with police investigations, and that's something that we often see failing in practice in the UK. At EU level, in December 2010, the EU Parliament voted on the EU Trafficking Directive and appointed Mireia Vassiliadou as the EU Anti-Trafficking Coordinator. She has a central role in developing EU trafficking policy, which is very important. The Trafficking Directive entered into force in the UK in April 2013, and it's a directly effective measure, as the Supreme Court found in Hunger and Allen. Now, the government has also been keen to make announcements as to its commitments to protect victims of trafficking. In the UK in 2011, David Cameron announced the government's decision to opt into the EU Trafficking Directive, stating that we are and will continue to be world leaders in tackling this terrible crime and ensuring victims are protected. Last year, the Home Secretary, Theresa May, took up that baton and announced a modern slavery bill to give law enforcement the tools they need to target today's slave drivers, ensure perpetrators are severely punished, and improve support and protection for victims. As I've mentioned, today the bill has reached the report stage in the House of Lords for further line-by-line examination following the committee stage in December, when a number of amendments were tabled to the Lords. The timetable is for the bill to attain royal assent and become law in April 2015. I've been working with other lawyers and NGOs on the bill to ensure that it really is fit for purpose, although there were real concerns about that, and I will come back to that later on. So to briefly recap on a keynote address about developments at EU level and examples of non-implementation in the UK. We were privileged to be able to welcome Dr. Mireia Vassiliadou, the EU Anti-Trafficking Coordinator, to Chambers to give a special keynote address on the 9th of February. She explained to us the priorities and developments at EU level and clearly pointed out that trafficking and modern slavery are distinct though linked concepts. To my mind, that's the distinction that is being blurred here in the UK, both in the current political debates on the modern slavery bill and in the bill itself. Mireia was joined by members of our anti-trafficking team, including Edward Fitzgerald QC, Charlotte Kilroy and Ben Newton, who spoke on civil and criminal remedies for victims of trafficking. Striking examples of non-implementation of the UK's obligations were given. On the civil side, successful civil claims by victims of trafficking are few and far between. There is only one reported judgment in the UK, of which we are aware, in which victims of trafficking secured compensation from their traffickers post-conviction. That's 80 and others and Ulgieru. That's also despite the clear obligations to ensure that victims are compensated in the Convention and in the directive. I and others have been arguing for civil remedies for victims of trafficking to be effective, and the Lords have tabled an amendment to the bill to that effect. We hope that that amendment will be carried through. On the criminal side, Ben Newton spoke of the continued prosecution of victims of trafficking as defendants, despite being compelled to so act on account of a trafficking situation, and despite guidance on this from the Court of Appeal in RNLC. Anti-Slavery and others have questioned whether the new statutory defences for adults and children in the Modern Slavery Bill will go far enough, and that remains to be seen. So on to some recent developments in terms of tackling issues of non-implementation and developments throughout 2015, starting from recent developments. Those of us working on the Modern Slavery Bill have argued that there needs to be a comprehensive framework for protection of victims in the UK. Firstly, it's unclear whether or not the Modern Slavery Bill will actually cure this problem. The major problem, in my view, is that the internationally recognised definition of trafficking is missing from the Modern Slavery Bill, and in practice it's not applied either. Secondly, it remains to be seen whether the amendments tabled by the bill to the Lords, to the bill, on the creation of a tort of trafficking, on legal aid provision once indicators of trafficking are shown, will be carried through when the bill returns to the Commons. Again, these are the minimum standards for the effective protection of victims that we would expect to be seen in a modern slavery bill. Thirdly, with that in mind, it has to be remembered that the EU Trafficking Directive itself sets down minimum standards for the protection of victims, and the deadline for transposition was December 2013. The UK notified the EU that it had happily transposed the directive, though we as lawyers and campaigners would seek to disagree. This year, however, the EU Commission will report to the EU Parliament on the extent of compliance by Member States with the directive, and the UK's report is expected soon. We will be providing comments on the UK report pursuant to Article 20 of the directive and seeking to assist the Commission with its important review. Fourthly, this year, the Council of Europe group of experts against trafficking in human beings, GRETA, will commence its second evaluation round for the purposes of preparing a second report on the UK. Again, we will be seeking to provide input on this report, in particular giving concrete examples, as stated earlier, that the Convention is not being implemented in practice in the UK. Fifthly, to mention some domestic reviews, which again illustrate the mismatch or potential mismatch between written commitments and implementation in practice. Firstly then, the review of the NRM. The major problem that we see is the role of the Home Office in victim identification and immigration control. The Joint Select Committee on the Modern Slavery Bill last year recommended that victim identification be taken out of the hands of the Home Office. In November 2014, Jeremy Oppenheim, as head of the UK Visas and Immigration, published the Home Office final report on the NRM. In that report, the need for the system to be changed was accepted. However, the government has shown a willingness to release the Home Office from any role because of its immigration priorities, and that remains a key concern. Secondly, to mention that on the 9th of February, Theresa May, during parliamentary questions, announced two important reviews. The first is a review of the overseas domestic worker visa provision in the immigration rules, which ties a victim to their exploitative employer, prevents switching employers, and turns vulnerable victims of trafficking into illegal migrants if they try to escape. The terms of reference of that review, on one hand, ask whether the visa arrangements are effective to protect against abuse, and on the other, considers the need to protect the integrity of the immigration system. And that's, again, another real problem. The report is to be presented to the Home Secretary in July 2015, but this will significantly post-date the entry into force of the Modern Slavery Bill. The concern there is that this review will sidestep the existing support for the Overseas Domestic Worker Amendment to the Modern Slavery Bill. The second review announced was of the welfare of immigration detainees, though it remains to be seen if and how this will properly take into account the welfare of victims of trafficking. An immediate problem is seen because the current published policy on detention of victims of trafficking in Chapter 55.10 and Chapter 9 of the Enforcement Instructions and Guidance, as they relate to the detention of victims of trafficking, require formal recognition before release. Again, to my mind, this is only contributing to the concerns raised by Greta and others regarding the detention of victims of trafficking, but no doubt we'll be reporting to Greta further on that. Finally, to have a quick update on developments in the courts. The domestic courts here in the UK are being called upon to understand and apply law and policy designed to protect victims of trafficking, though we've seen mixed results as recent judgments in the Court of Appeal have illustrated well. On the 5th of February, the Court of Appeal ruled on 2 cases where the issue was whether or not claims by victims of trafficking for compensation in the Employment Tribunal were blocked by the doctrine of state immunity. In one case, Ben Kabouche and the Embassy of the Republic of Sudan, the Court of Appeal considered the claims by employees of the embassies of Sudan and Libya that Section 16(1)A and 4(2) of the English State Immunity Act 1978, the SIA, were incompatible with Article 6 of the European Convention on Human Rights and Article 47 of the Charter of Fundamental Rights of the EU. Both Article 6 and Article 47 relate, as we know, to the right to fair trial. In its judgment, the court determined that Sections 4(2) and 16(1)A were incompatible with Article 6 of the ECHR, and a declaration of incompatibility would be made, indicating to Parliament that the SIA requires further amendment. Furthermore, the court found that these sections also violated Article 47 of the EU Charter and that they should be disapplied where the claimant's claims were derived from EU law measures. However, in the second case of Reyes and another, the court held that the 2 victims of trafficking could not pursue their claims despite the seriousness of their allegations because the doctrine of immunity trumped any rights they had as victims of trafficking. So again, there's a real mismatch between the convention obligations and how they are applied in practice or indeed enforced by the courts. In December 2014, the Court of Appeal ruled on the exceptional case funding challenges in Gudanovician and Director of Legal Aid Casework. The Court of Appeal found in the case raising trafficking issues that the directive, the ECAT and Article 4 do not require legal aid to be provided to victims of trafficking in relation to an application for leave to remain prior to the determination by the competent authority that there are reasonable grounds for believing that the person is a victim. The ruling does not shut out successful applications for exceptional case funding under Article 8, depending on the facts of the case. I and Clara Connolly at ATLU represent LS, and we are seeking permission to appeal to the Supreme Court on that point. Finally, just to mention the detained fast-track challenges, which have real implications for victims of trafficking. The detention action challenge is listed for hearing on the 6th of March, and I just wish to mention a further 11 linked individual challenges regarding the failure to apply safeguards which are currently in the pipeline. And I, together with Wilson's, represent one of the claimants who is a victim of trafficking. So the point there is that there are many important areas for individual and strategic challenges in the courts and much work for us to do. Do keep in touch with us for further developments, including training on the obligations and implementation of those obligations when the new Act comes into force, and for further events during the year. Thank you so much for your time.